Hello guys, and welcome back to my lecture. On today's lecture, we'll be talking about fact and fact in issue. But this particular class, we will be talking about fact. In my next class, I'll be discussing about fact in issue. So what are facts? And why exactly are they very important when it comes to the law of evidence? Now you see, whenever there is a problem before the court, what the court is concerned with is what are the facts. Do you understand? So for example, let's take the case of Miriam Sanders, who allegedly killed Biliaminu Bello. Now the reason I'll be using different examples is because for you to understand and appreciate the law of evidence, you need to put yourself like a lawyer in court trying to argue for your client, because the law of evidence is basically not useful when it's not being applied in court. Do you understand? We can break the rules outside when it comes to evidence. I mean, I can get illegally obtained evidence from any other person. I use it to threaten you. But illegally obtained evidence cannot be used in court. Do you understand that? Except there is an exception to that. But when we are learning that, we'll discuss about it. Each time you are having a class of this nature, law of evidence, always try to put yourself like a lawyer. Try to put on your lawyer thinking cap. What will you do if you were in court? So now, let us give an example of Miriam Sanders and Biliaminu Bello, like I stated earlier. What happened? I made a video on YouTube on this where I literally broke everything down regarding this particular issue, but I'll just take the salient facts. So Miriam Sanders got married to Biliaminu Bello, and then during the course of their marriage, she realized that he was cheating on her. Then she saw naked pictures on his phone. She got furious at some point. Biliaminu Bello knew this, so he hung out with some of his friends. But obviously, there's always a time to come back home. So he decided to go back home, and then he went back home with Ibrahim Muhammad, one of his friends. Now, when they were at home, they realized that Miriam Sanders was very angry, very furious that Biliaminu Bello would do something like that. I mean, finding naked pictures on her husband's phone is a presumption that something must have gone down between him and the girls. Now, because of such rage and such anger, she charged at him so many times. And Ibrahim Muhammad stated that he removed knife from her hands a lot of times. He said 4 times. And also removed groundnut bottle from her hand, broken one, one time. Now, where Ibrahim Muhammad had to go home, he left, and then 1 hour later thereabout, he heard that Biliaminu Bello has been rushed to the hospital. Now, you are the lawyer for Miriam Sanders in this case. As a lawyer and someone who is learning the law of evidence for the first time, the first question you need to ask, the first thing you need to look at is, what are the facts? What are the facts presented before you? Now, you know that she saw certain things on his phone. You know that she got angry. You know that she charged at him. You know a lot of things. But then, for you to understand what the fact is, let us go to the definition of fact under section 258, subsection 1 of the Evidence Act. And what does section 258, sub 1 of the Evidence Act say? Now, it tells us that a fact includes anything, state of things, or relation of things capable of being perceived by the senses, and any mental condition of which any person is conscious. Now, if you look at my notes, I said that the importance of facts in the law of evidence is highlighted in the Supreme Court case of ABIA State versus AG Federation, where the court stated that it is elementary that a case is decided on facts before the court. It is now an axiom or an aphorism to say that facts are the fountainhead of law. I love that. Facts are the fountainhead of law, which is something that you must know. Law, when you are about to apply it, has to be applied on facts. Where there have been no facts, there can be no law. Do you understand that? I am talking about the confines of law of evidence in the courtroom. when you are in a courtroom, the only time you can apply law in a particular situation is where fact has been adduced. Do you understand that? So now let us look at the first thing. Anything, state of things, relation of things. That is what I would like to call the act in itself. Do you understand that? So anything, state of things, relation of things. The fact that Miriam Sanders saw naked pictures on Biliaminu Bello's phone is a fact, because it shows the state of things. She saw it. Do you understand what I'm saying? Now, when we move further with what a fact is, you talk about state of things, relation of things. Just know that the first part, that's the A part of section 258, subsection 1, defining fact, talk about the actus reus. That's the act. That's what I call it, the act. When you go to B, it then talks about mental condition to which anybody is conscious. Mental condition. Now, you can see that Miriam Sanders, as at the time she charged at Biliaminu Bello severally, it proves one thing, that she was angry. That is a mental condition. So you see, when you are trying to adduce evidence before the court, you adduce acts and you adduce mental conditions. Anything outside this cannot be adduced before the court. Do you understand that? And that is the reason that people say that you cannot prove witchcraft. How do you prove witchcraft? Do you understand? It doesn't come under A. Do you understand? It doesn't come under state of things. It doesn't come under relations of things. Do you understand? Because here it says anything, state of things, or relation of things capable of being perceived by the senses. Your eye, your ear, your nose, your mouth, or your body, that's the feeling, can touch it. Do you understand? If it's something that your body cannot perceive, then it cannot be a fact, except it is also mental condition to which a person is conscious. So the first part talks about the actus reus. I saw the naked picture on his phone. I felt him touch me. I perceived something, like smell something. Do you understand? It's a fact. You might not have seen it, but you perceived it. So I'm in my room, and then I can perceive burning wire, and that was the reason I stepped out of my room. I perceived burning wire and I stepped out. They are both facts. Do you understand? So that is the first point of the law of evidence. What is a fact? So now, as a lawyer and as somebody who now knows what a fact is, I want you to look at the scenario that I painted on Biliaminu Bello's case. What are the things that you are going to look out for? What are the things that will help your client? What are the facts that will help your client in that particular matter? That your client there being Miriam Sanders. And then in next class, we are talking about fact in issue. Don't forget that in the case of AG ABIA versus AG Fed, it tells us that fact is the fountainhead of law. So if fact is the fountainhead, what then is fact in issue? That is what we'll be discussing in our next class. See you in my next class.